Former President Donald Trump is facing a civil lawsuit right now. 6 protesters accuse his security guards of assaulting them outside Trump Tower. That incident happened back in 2015 when Trump was running for president. Meanwhile, there is new reporting that Trump is pushing for total immunity from any civil lawsuits relating to the January 6th.
It was a ruling that sliced straight through the legal fortress the Trump team had spent months constructing, a decision that landed like a thunderclap on March 31, 2026, shaking the foundations of what many believed was an impenetrable shield around the former president. U.S. District Judge Amit Mehta, after poring over arguments and evidence for what felt like an eternity, delivered a blow that no amount of constitutional maneuvering could fully deflect. He looked at the fiery speech delivered from the ellipse on January 6, 2021, the one urging the crowd to fight like hell as they marched toward the Capitol, and declared it was not protected by presidential immunity, not even close. This wasn't some sweeping political attack, it was a precise, carefully reasoned legal determination. Mehta ruled that the speech was a private political act, delivered by a man acting more like an office seeker desperate to cling to power than an office holder faithfully executing the duties of the presidency. It fell outside the boundaries set by the Supreme Court's landmark immunity decision from July 2024, which had granted broad protections for core official acts but left unofficial conduct exposed. A campaign rally speech designed to pressure Congress into rejecting the Electoral College results? That, the judge made clear, was not a core official act by any stretch of constitutional imagination. It was political theater, raw and unprotected, aimed at advancing personal electoral interests, rather than discharging presidential responsibilities. The implications hit hard and fast. Civil lawsuits filed by Capitol Police officers who had stood in the breach that day, and by Democratic lawmakers who had huddled in fear as the mob surged through the halls of Congress, could now move forward. Trump could be held personally liable in civil court for damages stemming from conduct that plausibly crossed into incitement. The emotional weight of it all was impossible to ignore, the officers battered and bloodied while defending the seat of democracy, the lawmakers hiding under desks, their workplace turned into a battlefield. These weren't abstract plaintiffs, they were real people whose lives were upended, whose sense of safety was shattered, and who had waited years for any form of accountability after the criminal pathways were largely sealed off by the immunity ruling. Imagine the scene on that cold January day in 2021. Thousands gathered at the ellipse, fueled by months of heated rhetoric about a stolen election. The president stepped to the microphone, his voice rising with intensity, telling supporters to fight like hell, warning that if they didn't, they wouldn't have a country anymore. The crowd, already charged with emotion, began its march toward the Capitol. What followed was chaos, windows smashed, barriers overrun, officers overwhelmed, the certification process halted in terror. For the plaintiffs in these civil cases, that speech wasn't just words on the wind, it was the spark that plausibly ignited the violence, leaving scars that time hadn't healed. Mehta's ruling didn't dismiss the Supreme Court's immunity framework. Far from it, he embraced it, applying it with surgical precision. The July 2024 decision in Trump v. United States had established that former presidents enjoy absolute immunity for core constitutional acts, presumptive immunity for other official acts within the outer perimeter of their duties, and no immunity at all for unofficial private conduct. Trump's legal team had leaned heavily on that ruling, arguing it should blanket even civil liability for anything tied to January 6. They celebrated it as the ultimate shield, the definitive end to accountability for that chaotic chapter, but Mehta saw the gap and he drove right through it. The ellipse speech, he concluded, was not official. It was campaign activity, pure and simple, an effort to rally supporters as a candidate fighting to overturn results, not a president executing lawful authority. To understand why this distinction matters so deeply, you have to go back to the heart of the Supreme Court's reasoning. Chief Justice Roberts, writing for the majority, had been careful to draw lines based on the separation of powers. Presidents need breathing room to make bold decisions without constant fear of prosecution or lawsuits chilling their every move. Core functions like pardons, commanding the military in official capacities, or directing federal agencies in their statutory roles, those get the strongest protections. But a rally speech pressuring lawmakers to reject certified electoral votes to keep the speaker in the White House, that doesn't fit. It's the kind of private political maneuvering that even a sitting president engages in as a candidate, not as the embodiment of executive power. Mehta's analysis hammered this home, distinguishing the speech from other statements Trump made that day. like those from the Rose Garden, which were delivered in his official capacity using White House resources to address the unfolding crisis as commander-in-chief. Those the judge protected, showing he wasn't out for blanket condemnation but for constitutional fidelity. This careful line drawing makes the ruling not just significant but durable. Appellate courts don't lightly overturn decisions that apply Supreme Court precedent with such nuance. The Rose Garden protection alongside the rejection of immunity for the ellipse speech demonstrates balance. It proves Mehta wasn't simply ruling against Trump on partisan grounds. He was honoring the framework the High Court laid out, recognizing that official acts deserve safeguards while private political acts do not. That precision strengthens the decision's legal legs, making it far harder to dismantle on appeal. Trump's team would have to argue either that Mehta misapplied the immunity logic, or more awkwardly, that a campaign-style rally speech to disrupt certification somehow qualified as a core presidential function. The latter strains credulity, even in the most sympathetic courtroom. The fight like hell language took center stage in Mehta's analysis, and for good reason. Under long-standing First Amendment doctrine, most political speech enjoys broad protection. But there's a narrow exception rooted in the Brandenburg v. Ohio standard: speech directed at inciting or producing imminent lawless action, and likely to produce it, loses that shield. The judge found that in context the remarks plausibly met that threshold. The crowd wasn't abstract, it was energized, directed toward the Capitol, and violence erupted soon after. This wasn't a criminal finding of guilt beyond a reasonable doubt. That bar is high and different. But in civil court, where the standard is preponderance of evidence, it opens the door to liability for the harms that followed. For the Capitol police officers, many of whom suffered physical injuries, trauma, and lasting PTSD, this ruling feels like a lifeline. They defended the institution with their bodies and badges, facing a mob that believed it was answering a call from the highest levels. Democratic lawmakers like Rep. Pramila Jayapal and others who brought suits weren't seeking criminal punishment. They wanted recognition of the terror they endured while doing their constitutional duty, certifying an election, hiding in secure locations, hearing the glass break and the shouts echo through the halls, wondering if the chamber would hold. The emotional toll has been profound, a wound on the body politic that civil damages can't fully heal but can at least acknowledge through accountability. Now in April 2026, this decision lands amid a perfect storm of challenges for the administration. The second term is already a whirlwind. Iran tensions flaring into conflict, oil prices spiking, economic pressures from tariffs rippling through markets, a MAGA coalition showing visible fractures, and a wave of impeachment calls echoing across the country alongside hundreds of nationwide lawsuits. Personal financial exposure from civil verdicts adds another layer of vulnerability. Unlike criminal cases that might end in incarceration, civil liability means damages paid from personal assets, a tangible hit that could fuel narratives about fitness and distraction at a time when focus on governance is critical. A sitting president facing potential payouts for January 6 related harms while juggling foreign policy crises and domestic unrest creates a political pressure cooker with no easy release valve. The timing amplifies everything. One legal setback in a week might be spun as an activist judge or a minor hurdle. But when losses pile up across domains, asylum policies, immigration blocks, National Guard deployments, and now this piercing of the immunity armor, the pattern becomes harder to dismiss. It's not just noise, it's a documented wave of judicial pushback testing the boundaries of executive power in real time. The immunity ruling was meant to close the book on January 6 criminal accountability, and in many ways it did. Federal cases largely faded after the election, but civil pathways remained open, and Mehta just widened the door. Let's linger on the human stories, because they give this ruling its emotional core. Picture the Capitol police officer, badge tarnished with sweat and blood, standing against waves of protesters who saw themselves as patriots on a mission. Many officers later spoke of the betrayal they felt, not just from the mob but from the sense that their commander-in-chief's words had helped unleash it. For lawmakers, the day wasn't politics as usual, it was survival. Phones silenced, hearts pounding, the weight of history pressing down as certification teetered. Years later, the lawsuits represent their refusal to let the moment fade into forgotten history. They want the record to show that words have consequences, that even the most powerful aren't above the civil consequences of actions that plausibly endanger others. Meta's decision also carries broader ripple effects for the accountability landscape. By establishing on the federal record that the ellipse speech was private political conduct rather than official, it becomes precedent that other proceedings can cite. Congressional committees, especially if control shifts, could lean on it in hearings. Future civil claims or oversight efforts gain a judicial anchor, not just partisan allegations. It's not the end of the immunity shield, but a clear documentation of its limits, a gap shaped precisely like that rally speech through which civil plaintiffs can now advance. Drilling deeper into the legal architecture reveals why this isn't a fluke but a logical extension of existing doctrine. The Supreme Court had remanded questions of official versus unofficial acts to lower courts, emphasizing fact-specific analysis. Meta did exactly that, examining the content and context of the speech. It wasn't about executing laws or foreign policy, it was about rallying supporters to challenge certified results, framed in campaign terms. The office seeker versus office holder distinction isn't invented law, it's implicit in the immunity ruling's focus on presidential functions. A president can wear multiple hats, chief executive one moment, candidate the next. When the latter dominates, protections don't automatically follow. This distinction is likely to hold up under scrutiny because it respects the Supreme Court's own boundaries. Overturning it would risk undermining the very precedent Trump's team invoked. Appellate review will focus on whether the application was correct, not on rewriting the framework. The careful protection of Rose Garden remarks, official updates during the crisis, underscores that Meta wasn't cherry-picking, he was dissecting the day's events with constitutional scalpel. That balance lends credibility, turning what could have been a politically charged opinion into one rooted in precedent. Financially, the stakes are real and personal. Civil damages aren't prison time, but they carry their own sting. Public judgments against a sitting president, potential payouts draining resources, ongoing discovery that could unearth more details from the January 6th orbit, depositions, documents, witness testimony, all resurfacing in a forum where the immunity wall has a hole. This sustained narrative of liability runs parallel to other pressures, military engagements abroad, economic turbulence at home, internal coalition strains. No modern presidency has navigated quite this combination, creating a sense of perpetual siege that tests resilience and focus. The ruling doesn't erase the Supreme Court's victory for Trump in 2024. That decision remains a monumental expansion of protections for official acts, ending certain criminal threats and reshaping how future presidents operate. But every shield has edges, and Meta illuminated one. The biggest legal win of Trump's career now has a documented vulnerability, one the civil cases are poised to exploit. Discovery will proceed, trials potentially loom, and the story of January 6th, its causes, its consequences, refuses to be fully buried. As the cases advance, the human element will stay front and center. Officers recounting the fear and fury of that day, lawmakers describing the violation of their sacred workspace, families still carrying the emotional load. Plaintiffs aren't chasing vengeance. They're seeking a measure of justice in the only arena left open. The fight like hell words, once rallying cries, now face examination under the cold light of civil liability standards. Was it protected fervor or something that foreseeably led to lawlessness? Courts will weigh it, juries may decide, and the public will watch. In the broader tapestry of the second term, this moment in late March 2026 stands out as a pivot. Legal pressures aren't isolated, they intersect with policy battles, public approval dips, and coalition fractures. A 36% approval rating amid multiple fronts of conflict amplifies every setback. Personal liability adds a layer of distraction and vulnerability that no communication strategy can fully neutralize. The pattern of judicial outcomes across immigration, war powers, and now January 6 civil claims suggests a system pushing back against expansive interpretations of executive authority. Looking ahead, the civil suits will grind forward through discovery phases, building a record that criminal cases might have but didn't after immunity took hold. Documentation of planning, communications, and the rally's aftermath will surface, feeding not just litigation but public discourse. The office seeker framework Meta applied becomes a tool for other accountability efforts, keeping the January 6 chapter alive through the midterm horizon and potentially beyond. It's not criminal jeopardy, but it's accountability nonetheless. Financial, reputational, historical. The emotional resonance can't be overstated. For those who lived January 6, the ruling reopens wounds but also offers validation. Democracy took a hit that day. Now the courts are affirming that certain actions carry consequences even for the most powerful. It reinforces that while presidents wield immense authority, they don't operate in a vacuum immune from every repercussion when stepping into private political arenas. The balance between robust executive power and accountability is delicate, and this decision tugs at it thoughtfully. As April 2026 unfolds with its wars, economic strains, and political tempests, this ruling adds to the turbulence. Trump's team will appeal, argue distinctions, seek stays. Plaintiffs will push for trials, eager for their day in court. The nation watches a drama unfold where legal technicalities collide with raw human stories, where immunity's fortress reveals its cracks, and where the echoes of Fight Like Hell still reverberate through the halls of justice. The gap is real, the cases are proceeding, and the story of January 6 finds new life in civil courtrooms, reminding everyone that words spoken from the ellipse carried weight far beyond the moment, shaping lives, laws, and legacies in ways still unfolding. The precision of Mehta's opinion, spanning dozens of pages, grounded in evidence and precedent, ensures it won't fade quietly. It distinguishes acts with clarity, official communications from the White House protected, rally exhortations to supporters not. This isn't rewriting history, it's applying constitutional tests to specific facts. The Brandenburg analysis on incitement adds depth, acknowledging that even passionate political speech has limits when it plausibly veers toward imminent harm. In a polarized era, such judicial restraint stands out, neither overreaching nor shying away from tough calls. For the administration, managing this alongside Iran developments, tariff fallout, and coalition dynamics requires juggling unprecedented balls. Personal financial stakes raise questions of distraction. How does a president focus on global crises when civil discovery demands attention and resources? Public perception shifts as narratives of ongoing liability persist, chipping at images of strength and finality that the immunity win was meant to project. Midterm clocks tick louder with every layer of exposure, turning legal proceedings into political liabilities that campaigns must navigate. Yet the ruling's durability stems from its restraint. It doesn't challenge the Supreme Court, it operationalizes it. By protecting some acts while exposing others, it models the fact-bound inquiry the High Court envisioned. Appellate panels, regardless of composition, will grapple with whether that application holds. Arguing a rally to halt certification is core presidential duty tests the limits of credulity, forcing defenders into uncomfortable doctrinal corners. The plaintiff's persistence over 5+ years speaks volumes. Capitol Police, many still bearing physical and psychological scars, pursued this when criminal avenues narrowed. Lawmakers, targeted in their own workplace, refused to let the day define unchecked power. Their suits humanized the abstract, damages for medical costs, therapy, lost wages, emotional distress. Verdicts, if they come, won't rewrite the Constitution, but will affirm that even presidents face civil reckonings for unofficial conduct. In the end, March 31, 2026, marked not the collapse of immunity but its clarification, a reminder that protections have boundaries drawn by the Constitution itself. The ellipse speech, with its charged rhetoric and immediate aftermath, crossed into unprotected territory. Civil cases now advance, discovery looms, accountability narratives endure. Amid the second term's chaos, conflicts abroad, economic pressures, internal divisions, this legal development adds depth to the portrait of a presidency tested on multiple fronts. The fight continues not in criminal courts alone, but in civil ones where personal liability meets historical reckoning, ensuring January 6 remains a chapter whose final pages are still being written in the slow, deliberate hand of justice. Expanding on the context, one must appreciate how the Supreme Court's 2024 ruling reshaped the landscape. It wasn't a blank check, it demanded nuance. Core acts like foreign affairs or pardon power get absolute cover to prevent judicial second-guessing of executive functions essential to governance. Presumptive immunity for official acts allows rebuttal if needed. Unofficial acts, none. Mehta's task was to classify the speech within that triad, and he placed it firmly in the unofficial bucket. Evidence showed it as part of a Stop the Steal effort, rally logistics tied to campaign goals, language aimed at supporters as voters rather than citizens receiving official guidance. This classification resonates because it aligns with everyday understanding of roles. Presidents campaign while in office, but those activities don't magically become official duties. Fundraising, rallies, election challenges, these are partisan endeavors, even if conducted from the White House. The Ellipse event was permitted as a political gathering, not a state address. Its purpose to influence the joint session of Congress on certification. That pressure tactic, however fervent, doesn't transform into a presidential function under separation of powers principles. Roberts' opinion warned against distorting executive decision-making through fear of liability. Mehed ensured that fear doesn't extend to purely political spheres. The incitement plausibility finding adds another dimension. Brandenburg requires intent, imminence, and likelihood. Context mattered. The speech followed months of claims, came just before the march, used urgent language amid a charged atmosphere. While protected speech often includes hyperbole, the judge saw enough to let claims survive summary judgment. This doesn't convict, it allows evidence to be tested at trial. For plaintiffs, it's validation that their suffering warrants examination, not dismissal on immunity grounds. Emotionally, the ruling stirs deep currents. Supporters of Trump see it as another example of lawfare, endless litigation to undermine a mandate. Critics view it as overdue justice, a check against norm erosion. The truth lies in the legal mechanics, a judge applying precedent to facts, protecting some conduct while exposing others. That nuance prevents it from being mere theater. It invites appeals but sets a marker that unofficial acts carry risks, even for presidents. As discovery begins, expect revelations, internal communications, planning documents, witness accounts that could illuminate the days leading to January 6th. Not for criminal ends but civil ones, proving causation, quantifying harms, officers detailing assaults, lawmakers recounting fear, experts on crowd psychology. The process itself becomes a public accounting, replaying events through testimony rather than sound bites. In the turbulent April 2026 environment, this adds fuel to existing fires. With approval ratings strained, coalitions tested, and multiple crises demanding attention, the specter of personal liability looms as a constant undercurrent. It raises questions about governance capacity. Can focus remain sharp when courts demand responses? Assets face potential claims. Political opponents amplify it as evidence of vulnerability. Allies frame it as persecution. Either way, it sustains a narrative of unfinished business from 2021, intersecting with fresh challenges in ways that compound pressure.